Hello and welcome to today's webinar. My name is Mark Craig and I'm Associate Director here at Jordan's. This webinar is the second in a series provided free to our clients and partners and can be set against your continuous professional development requirements. It's being recorded and will be available to download from our website in due course. I'm joined today by my colleague Simon Bates, Executive Director, Solicitor Commercial at Jordan's Corporate Law.
Hi everybody.
Our webinar today will highlight some of the key terms of GDPR. We'll talk about the steps that organisations should take to comply with GDPR, and we'll offer some thoughts and quick fixes for how to comply with the regulation. Due to the number of attendees on the call today, you've been put on mute for the duration of the webinar. However, as this is designed to be an interactive event, I'd be grateful if you could email me with any questions throughout the session. My email address is on screen, just highlighting it now. It's mark_craig@jordans.co.uk. Any questions we don't manage to get through today will be answered by email after the event. So without any further delay, let's begin today's webinar. Over to you, Simon.
Good afternoon everybody. As Mark said, the purpose of the webinar today is to tell you a bit about GDPR. As you can see from the slide, I'm dividing the talk into parts. We're going to look at the basics of GDPR, and I will then talk through some various practical examples of the impact of GDPR. We'll finish by talking a bit about how Jordans can help. And as Mark said, if you do want to email any questions, if we don't have time to deal with the emailed questions this afternoon, we will respond to those in due course. So, what is GDPR? GDPR stands for the General Data Protection Regulation, and it is brand new data protection law that is coming into effect on the 25th of May 2018. The reason we've got this, or the official reason should I say, is to ensure harmonisation of data protection laws across the European Union. Generally speaking, I think the UK is quite neutral when it comes to data protection laws in the European Union. Germany is a lot more strict, but there are certain countries, certainly in Eastern Europe, where if you fail to comply with data protection laws there are in fact no sanctions. The real headline on GDPR is the increased fines. So the maximum fine for non-compliance is 20 million euros or 4% of turnover, whichever is the higher.
We were talking about that the other day, Simon. That's a 1 billion euro turnover company. Let me get that right. That's a 40 million euro fine potential. Is that right?
Yeah, that's absolutely right. Yeah, potentially a 40 million euro fine in those circumstances. But I suppose you compare that with, say, a 1 billion euro turnover company in the UK at the moment, the maximum fine that it can currently suffer is £500,000. So you can see, therefore, that organisations and companies are going to have to take data protection legislation and compliance with data protection legislation much more seriously going forward. Another impact I think we'll see is that there are going to be real commercial pressures on businesses to comply with GDPR, particularly if they are a data processor. Indeed, if you are a data processor, you're probably already starting to receive quite complicated questionnaires about your GDPR compliance. And I'll talk a little bit more about why organisations are facing those commercial pressures shortly. One thing I think just to point out is worth saying is that Brexit will have no impact on GDPR. When GDPR comes into effect on 25th of May, the UK government is also bringing in legislation at the same time, which will mean that GDPR will continue to apply to the UK even after the UK leaves the European Union. So, in very simple terms, what does GDPR cover? Well, it's the law about how an organisation collects, uses and stores personal data. So if it covers the law about how an organisation handles personal data, what is it that we mean by personal data? Well, the strict legal definition is that personal data means information relating to an identified or an identifiable natural person. So what does that mean in practical terms? Well, I'll give you some examples. Your bank account and your bank account details and the balances on your bank account, that's all personal data. Your HR records is personal data. What you've ordered from Amazon is personal data about you. Where you live is personal data. And your email address, even a business email address, can be personal data. So, for example, my email address is sbates@jordanscorporatelaw.com. That identifies me, Simon Bates, as working at Jordan's Corporate Law. That's personal data therefore about me. Simple things, contact details, even if they relate, even if you're in a business-to-business relationship, those contact details that you place in Microsoft Outlook, for example, those are personal, that's personal data about those contacts. So it sort of disapplies the myth here. I think the GDPR doesn't apply to business-to-business relationships. It does, and we'll see a lot more about that as we go along. Emails that you send will often contain personal data. I mean, I suspect we've all done this once or twice in our time when our colleagues perhaps annoyed you and you then fired off an email to another colleague flagging that person off.
Never.
That's personal data about the person you've just flagged off. So we can see that organisations are going to have to be very careful about that type of thing. We'll talk about, again, a bit more about that in due course. In my view, it's almost impossible to think of a business, or indeed a not-for-profit for that matter, that does not hold personal data. I'm sure someone can one day come up with an example, but I've yet to see one. There's another myth that people also think that personal data only applies to electronic records. That's not true. It equally applies to manual records as well, so it's not just about techie stuff.
By manual you mean paper records, Simon, yeah?
Yeah, that's right. So, for example, that's absolutely right, Mark. So, for example, lots of HR records are kept offline for obvious reasons. They'll be kept in the filing cabinet, but that is all personal data. So, I'm trying to keep this as unlegal as possible, but I am going to illegal. Yeah, I am going to talk about some of the rules of GDPR, and I'll try and keep these quite simple and give some examples. So, I hope this will sort of illustrate the broad scope of GDPR. And as I say, it's not just about IT techie stuff. As I've already said, it governs how an organisation collects, uses and stores personal data, and what GDPR does is provide a set of rules around this. So let's just take a look at some of these rules. The first rule I've put up here is that an organisation has to tell you the purpose for which it's gathering your personal data. So I'll give you an example that we've probably all experienced. If you go into a retail store these days to purchase any item of clothing, when you go to checkout, they invariably say to you, can they have your email address for the receipt? Well, we all know that they're not primarily collecting your email address for a receipt. They're really collecting it so they can use it for marketing purposes. They're not telling you the true purpose for which they're gathering that personal data. That's a breach of GDPR. Another example is that you've probably all been to a website and you'll see at the foot of the home page there's normally something called a privacy policy or a link to the privacy policy. A privacy policy is where the website tells you what they intend to do with your personal data. Now, interestingly, there was some research by the Information Commissioner's Office, or the ICO, which is the UK body responsible for data protection enforcement in the UK, and they carried out some research last year, and they looked at 30 leading retail websites and their privacy policies. And their research found that of the 30 privacy policies that they looked at, and these were privacy policies under the existing data protection legislation, a staggering 26 of those 30 privacy policies were not compliant with existing data protection law. So really, if retailers can't comply with the existing law, they have absolutely no hope when it comes to GDPR. And in fact, one of the things that the ICO is saying about GDPR is that it is an evolution rather than a revolution. But I'm afraid to say that in my experience, most of the organisations I come across are not compliant with existing data protection legislation. So for all those organisations, GDPR is far more than an evolution. It is indeed a revolution. The next rule is that, subject to various exceptions, an organisation can only process an individual's personal data with that consent. Now, there are some exceptions, so I'm not going to go through those in great detail, but for example, you can, generally speaking, process, that means do anything with an employee's HR records without their consent. Now, under GDPR, where you are relying on consent, consent has to be freely given, specific and informed. So again, if we talk about websites, we'll all have seen those tick boxes that you have on websites, and getting someone to tick a box is a really, really good way of getting consent. But under GDPR, as I say, this consent has to be freely given, specific and informed. So, for example, you can't have, as you see on a number of websites at the moment, you can't have pre-tick boxes which says I consent to my data being used for marketing purposes, and it's already ticked, and you have to untick it. That is not freely given consent. Also, you will have seen on websites another one which says something along the lines of I consent to my personal data being used for marketing purposes by trusted third parties. Well, I've no idea what a trusted third party is, and GDPR doesn't either. That is, again, not an informed consent. You'll have to be more specific about what you want, what you intend to use, who these trusted third parties are. You might say, that I consent to my personal data being passed on to a bank tick or onto an insurance company tick, but you can't have generic terms like trusted third parties. And then there are even more stringent and complicated rules when it comes to getting consent from children. A good example of where these two rules interact and is JD Wetherspoons, and they have decided that as a result of GDPR, they are either deleting or may already have deleted their entire marketing database. And primarily this is because if you were going to JD Wetherspoons pub, you'll often find things like on the tables, you'll find a competition which says, answer this simple question, send us an email, and you might win some free beer or something like that. Now there was no consent there to use your email address for marketing purposes, and indeed JD Wetherspoon had no idea where all this information was coming from. So they have decided that they cannot comply with GDPR, and therefore, as I say, they have decided to delete their entire marketing database. Now, it's probably not as drastic for them as they're making out, because actually, to be honest, I don't think Wetherspoon's main method of marketing is through emails. But it just goes to show the sort of effects that GDPR is having on organisations and the sort of issues that they are having to address. The next rule I've got here is that personal data has to be adequate, relevant and limited to what's necessary for the purpose for which it's being collected. Well, what does that, sounds a bit legal, what does that mean in practical terms? Well, let's take EasyJet for example. If you in the past went to the EasyJet website and you wanted to book a flight, they actually asked you for your age. And when you went to the drop-down menu there, it gave you a number of choices. And it said under 18, 18 to 24, 25 to 34, 35 to 44, etc. Now, you're booking a flight. For the purposes of booking a flight, they don't need to know what age category you fall into. They need to know they only need to know whether you are an unaccompanied minor or not. So if you now go to their website and you book a flight, when you go and where it asks your age, on the drop-down menu there, it gives you two options. It gives you you're 18 or over, or you're under 18. And there, they have a legitimate reason to know that, because they need to know whether you are an unaccompanied minor or not. But before, when booking a flight, they had no legitimate reason for asking you your actual age grouping. The next one I've got here is that data has to be accurate and kept up to date. Now, the onus on that is on the company. So to give you so this probably means, for example, that you're going to get more of those annoying emails from HR teams and things like that saying, "Here's the data we hold about you. Is your address? Is your person to contact in the event of emergency? Is all that personal data up to date?" And it's up to the organisation to actually ask you those questions, not as an individual for you to actually pass that information back to them.
That reminds me of a client that contacted us recently, and they had a question about that, which was how frequent should they keep it up to date? So how frequent do they have to ask those employees to check their data? Is there any definitive answer on that?
I think we'll come on to that next, Mark. There's no definitive answer, and it's all about actually you setting your own policies and what's reasonable. And I'll talk about that now, actually, on this next rule, which says that personal data cannot be kept any longer than is necessary. So, as Mark's just asked the question of me there, it's typical sort of questions I get, which is things like, how long should personal data about employees be kept, or how long should I hold contact details in my CRM or marketing database? And I say, I'm often asked, how long? What does the law say is the correct time limit? Well, there isn't a simple time limit. It's up to your business to determine itself what's a necessary period, and then has to be able to justify its choice as to what period it chooses. So let's just take HR records, for example. As a business, you might determine that after an employee leaves, I should keep their payroll details for 6 years. And there's a good reason for that, is that an HMRC investigation can go back 6 years. So it would be a good idea to keep those payroll details for, say, 6 years. But what about other HR records? What about their absenteeism and details of their sickness? Well, after that employee leaves, what reason have you got for keeping that for 6 years? In my mind, there isn't a reason, but your business might come up with a reason. It might, for example, say, well, I might need to provide that for reference purposes. But how long should we be keeping it for? You might say, well, I can only keep that for 2 years because I'm only likely to get requests for that in the next 2 years or something like that. But your business comes up with its own policy, and it's important it determines its own policies before it faces an investigation, rather than having to come up with reasoning after it faces an investigation. As we'll see in a minute, GDPR requires organisations not just to comply with GDPR, but to demonstrate their compliance with GDPR. Let's continue looking at these these rules. The next one is that organisations have to implement appropriate technical and organisational measures to ensure that personal data is kept secure. So this is a sort of techie one, but it's not all techie. It obviously includes things like making sure your IT systems are secure, but it's about things like making sure that when visitors enter your building, they can't see personal data. It's about making sure that your staff are trained so they don't go around disclosing personal data. Next one here is that organisations can't transfer personal data outside the European Union, even if that is to another group company. And this is the one that lots of organisations fall foul of. And it's very difficult often I think, for companies in a group to actually comprehend this particular one. But it means that it's not possible to transfer personal data, say from an EU subsidiary company to a US parent company. Now, there are some exceptions to this, so transfers are allowed to certain countries, but there's only, I think, 10 countries on that list, and they include countries like Switzerland and Argentina, and even the Faroe Islands. Not that I've come across anyone who's ever transferred personal data to the Faroe Islands, but interestingly, it doesn't include the USA. Now, if you are in the European Union and you want to transfer personal data to a parent company in the USA, there are ways around that. One of the ways is that the US parent signs up to something called Privacy Shield in the USA. You can also put in place something called binding corporate rules, which are quite a long-winded and expensive procedure. Excuse me, I've not come across anyone who's ever used binding corporate rules. And the third way, and the way that's most commonly used, is to put in place an intra-group agreement that meets the model requirements of the European Union, and actually get the parent and the subsidiary company to sign up to those those contract terms and those model clauses. And that's the one most commonly used. But I'll give you another example of how how this rule does affect companies, and how the results can be quite surprising. So, for example, we recently did an audit on a client for its GDPR compliance, and they were using a CRM and marketing database.
Client relationship management.
That's right. Yeah. That's right. And that was full of obviously personal data. And going through this audit process, we actually discovered that the servers for this CRM database were actually in Asia. So in fact, personal data, even though someone was sitting in the UK in front of a PC terminal, tapping data, as far as they were concerned, just at the end of their fingertips, it was actually being transferred to Asia. So we had to implement a workaround, which we did. But it just goes to show how you can be unwittingly caught out by these things. So even if your server is in the European Union, but you allow access to that server from outside the European Union, that also unbelievably counts as a transfer outside the European Union, and is therefore not permitted under GDPR unless you can find one of the exceptions.
So that's someone in the US accessing a database in the European Union, but they're within the same company. So I guess even someone on their smartphone in the US when visiting from the European Union, is that right?
Yeah, that's right. I mean, and as I say, there are ways around that, and there's also the thing that you end up, if you were to, shouldn't we say this, but if you were to try to be 100% compliant with GDPR, you might find your business grinding to a halt. So at some point in time, you sometimes have to make some sort of commercial decisions on this. But yeah, you're absolutely right there, Mark. The next one is that organisations can only use data processors who provide sufficient guarantees that they'll implement appropriate technical and organisational measures to keep the data secure and that they will comply with GDPR. So, first question, again, this sounds very legal, but again, it's the sort of thing that lots of organisations can quite easily fall foul of. So, first of all, what is a data processor? Well, a data processor is simply someone who processes personal data on the instructions of somebody else. Now, processing sounds, again, quite technical, but it isn't. It's just the word that GDPR uses to mean doing anything with or performing any operation in relation to personal data. So it means handling or storing personal data or even transmitting personal data. So, for example, data processors include a business providing payroll services on behalf of its clients, any business providing any sort of hosting services or storing services on behalf of a client, any, as we've seen already, anybody providing a cloud-based CRM system, for example, again hosting personal data, and they are a data processor. And the problem is, as we've seen, that a customer of a data processor can only engage a data processor who provides sufficient guarantees that they will keep your personal data secure and comply with GDPR. So if you engage a data processor who is not giving those guarantees, then that is a breach of GDPR and you yourself could get fined. Therefore, any data processor who decides to ignore GDPR going forward is going to be at a massive competitive disadvantage because few customers, or certainly few well-informed and large businesses are going to be willing to contract with them unless they are giving sufficient guarantees that they are complying with GDPR. So, if you are a data processor, you may already find that you are being asked certainly by your large customers to give assurances about your GDPR compliance, to answer questions. I mean, I've recently seen one of these questionnaires, and it actually ran to over 80 questions about the data processor's compliance with GDPR. So you can see that there's going to be a lot of commercial pressure on particularly data processors to comply with GDPR. And then it goes on to say that any data processing agreement itself has to contain a set of mandatory terms. So in addition to the customer needing to carry out due diligence about the data processor, the agreement itself has to contain a whole raft of mandatory terms. So this means any business who engage a data processor, or indeed data processors themselves, will have to amend their contract terms before the 25th of May to ensure that they contain the mandatory terms. Otherwise, they'll find their customers just won't want to do business with them.
This is reminiscent, obviously, of what Jordan's are doing with contracts, matters engagement with our clients as well.
Yeah, that's right. So we're going through a very large exercise here at the moment to make sure that where we act as a data processor, we are making sure that our contract terms all going forward contain all the mandatory terms so that we and our clients are compliant with GDPR in that regard. The next rule is that an organisation is required to demonstrate its compliance with GDPR. So this is a bit bizarre because if you actually accidentally comply with GDPR, technically you can still get fined because you're unable to demonstrate compliance with GDPR. Yes, I know that sounds ridiculous, but that's what GDPR actually says. But it does mean that organisations need to be doing things like implementing measures such as staff training, and certainly if you are an organisation that's employing 250 or more employees, then you are going to have to keep some quite detailed records about your data processing activities. The next one is that individuals have a right to access their personal data. I've already said that means that even things like emails between two individuals, you've got to be quite careful about what you store and what is actually recorded. This has always been the case that individuals have a right to access their personal data, but what has changed here is that under the current law, an organisation can charge you £10 to access your personal data. Under GDPR, it's free. And also, under the existing law, an organisation has 40 days in which to respond to what we call a service access request. But under GDPR, that time period reduces to a month. GDPR in some cases requires organisations to appoint a data protection officer. Actually, this is actually quite limited, and I've heard, there's a bit of an urban myth, I think, that GDPR requires all organisations to appoint a data protection officer. No, that is not true. In fact, most organisations will not have to appoint a data protection officer. You're only really going to have to appoint a data protection officer if you're carrying out large-scale data processing of special categories of personal data. So special categories of personal data means things like medical records. So a hospital, for example, will have to appoint a data protection officer, but for most organisations, they won't have to appoint a data protection officer. Now that doesn't mean they shouldn't actually designate somebody responsible for data protection overall, but there's no mandatory requirement to appoint a data protection officer for most organisations. The final rule I want to look at is that in some cases, organisations will have to carry out what is known as a data impact assessment. Now, these are a complicated set of rules about when you need to make a formal assessment of the impact that your data processing is going to have. And you have to make a formal record of this. Now, this is only really going to apply if your organisation is involved in new technologies. But it is something where if your organisation is engaged or involved in new technologies or developing new technologies, then it is going to have to look at the circumstances in which it might have to carry out data impact assessments. So, what size of company needs to be concerned about GDPR? Well, I think, as I hope you might have seen from the examples that I've given, I can't think of a single UK company that will not be affected by GDPR in some way. I mean, look, just about every single company has employees and will be sending and receiving emails. And each one of those acts alone is processing personal data, so it's enough to have some sort of GDPR consequence. I say almost because I'm sure somebody can come up with an example about a company or an organisation that has no GDPR issues, but I've yet to see one. Again, there is no exemption from the application of GDPR for small companies. I've heard it said that GDPR doesn't apply to organisations employing less than 250 people. That is complete rubbish. It's a complete urban myth. GDPR applies to all organisations, no matter how many employees that they have. Yes, there are more detailed record-keeping obligations for companies employing 250 more employees, but GDPR, apart from that one particular area, GDPR will apply equally to any business, no matter what its size is. I've tried throughout this to talk about organisations rather than companies because GDPR applies to any business, no matter what its form is. It also applies to not-for-profit organisations as well. And it also applies, it's not just about an organisation established in the UK. It applies to an organisation that is established anywhere in the European Union. It also actually has a direct effect on organisations that are established outside the European Union. So, If you're outside the European Union, but you are selling goods or services to individuals in the European Union, it will apply to you. So if you are, for example, an organisation established in the USA and you are selling online to citizens in the European Union, you have to comply with GDPR. It also applies to non-EU established organisations that, and to quote GDPR, monitor the behaviour of individuals in the EU. This basically means if you are carrying any form of online tracking from outside the European Union on individuals in the European Union, you are caught by GDPR. Now, a lot of websites will use tracking cookies, so it could be said that if your website is using a tracking cookie, you're actually caught by GDPR, even if your website is outside the European Union. I'm not sure if that was ever the intention, but it's certainly that's what the wording of GDPR says. And organisations who are outside the European Union but are caught by GDPR also have an additional obligation to appoint a representative within the European Union.
Is there something that Jordan can help with that? I guess would we be able to help with a business who was in a non-EU jurisdiction appoint a representative in the European Union?
Yes, I mean certainly. I mean what we would be saying to non-EU organisations is that what they should be doing is they should be basically forming a separate subsidiary company that can act as that representative within the European Union, because there's actually nothing in the GDPR which says that the representative has to be independent, and it makes sense because the representative is on the hook for GDPR compliance that it actually creates its own subsidiary to do that.
Sure. Thank you, Simon.
How can Jordan's help clients with GDPR compliance? Well, we can obviously help with specific projects that clients have, particularly looking at discrete areas. So, as we've already seen, this could be as simple as making sure that they've got the correct consents for data processing. It can be amending and drafting data processing agreements to make sure they contain the mandatory clauses. It can be helping to make sure that they've got the necessary legal arrangements in place to allow transfers to go outside the European Union, particularly intra-group. We help clients on drafting, advising on policies. The really big I suppose, job that we do is that we carry out an audit or a gap analysis for clients. So here we find out what personal data a client holds, what they're doing with it, where they've got it from, where they're sending it. And then we're able to, from looking at that, we're then able to provide a report to the client telling them what steps they need to take in order to make themselves GDPR compliant. One of the questions that I'm often asked, and I'm being asked this more and more frequently, is there a quick fix? Isn't this just a case of us, filling in a precedent policy to make us compliant? Well, there's two answers to that. One, GDPR, as we've already seen, is not just about policies. In fact, I've barely mentioned policies on this. And even if it were about policies, it's not a standard fix, because what any organisation does with its personal data is normally unique to that organisation. That said, and I'll be honest here, if you've not already started your GDPR compliance now, depending upon the size of your organisation, it's going to be very difficult to get everything sorted by the 25th of May. So what we're saying to a number of businesses at the moment is that they need to concentrate on their public-facing documents. So, for example, it's about making sure that what's on their website is GDPR compliant. It's about making sure they've got the correct privacy policy, they've got the correct consents, and particularly if they are involved in data processing, it's getting their data processing agreements GDPR compliant, to make sure they've got the requisite terms in there. Because if you don't get your data processing agreements GDPR compliant, you'll find that your big clients simply won't do business with you. I've put a link on there just so that just to our website, so there's a lot more on there about the GDPR support that we offer and some more sort of general GDPR advice. So that's worth having a look at too. I think that is probably all for me for the time being, Mark.
Okay, thank you very much, Simon. It's been scary and interesting again, as usual. I think there's an opportunity here for anyone to email me with any questions that we can talk about. We have another 15 minutes or so on this webinar. My email address is on screen. It's mark_Craig@jordans.co.uk. If you want, you could email me any questions and we can answer them live in this session. As I say again, if we don't get through them all, we'll be able to address them by email after the event. We have our first question. What does a small organisation need to do to make their website compliant? We have a contact sheet for collecting basic details, i.e. name, email, phone number. I think this is obviously collecting up. Sorry, I'm paraphrasing here what I think the question is. I think that they're collecting up email addresses, contacts. So I guess their question is, what do they need to do to collect those email contacts compliantly?
Yeah, I suppose there's a couple of things here. I mean, first of all, and it comes back to the first two rules that we discussed. First of all, they've got to tell the organisation, they've got to tell the individuals whose details they are collecting through their website the purpose for which they're gathering that individual's personal data. So this comes down to basically the privacy policy. So GDPR actually quite helpfully sets out all the information that needs to be given to an individual in a privacy policy or any form of privacy notice. So it's making sure that they have a privacy policy that is compliant with GDPR. But again, I mean, and the thing I stress here is that GDPR doesn't give you exact wording, because what you are going to do with that personal data very much depends upon your organisation. And just by way of an example, we've been looking for a client, and we're looking at all their GDPR compliance at the moment. I won't obviously mention who they are, but interestingly enough, we looked at their privacy policy on their website last week, and it was pretty clear on that they just copied their privacy policy from somebody else, or perhaps even still their privacy policy had been provided by their website designers, and it was clearly completely and utterly inappropriate for what they were doing with the personal data. In fact, actually, they were, according to the privacy policy, they were doing all sorts of things with their personal data which they simply weren't doing, because they weren't even in that business. So that just goes to show you that a lot of this stuff people just think is routine, and we'll just use any old privacy policy, but it isn't. I mean, as I said, we had the ICO look at privacy policies a few months ago and find that most were not compliant with the existing law. There's also the other side to that, is depending upon, there's not just enough to say under GDPR to say what you're doing with the personal data. You also have to, if you're doing anything with the personal data, you also have to get consent to do those things, unless you can rely on one of the exemptions. So if, for example, you were gathering that personal data and passing it on to a third party for marketing purposes, then you would, as well as telling the individual that's the purpose you were gathering it for, you would also need to get consent to enable you to do that.
We had a question last week as well, on the week before, on the previous webinar, which was kind of along the lines of, do I have to apply to become a data processor for GDPR? And I think it might be useful to reflect on that as well. I know you've answered it through the course of this, but I think there's some confusion out there.
There is. I mean, GDPR is not a case of registration. That said, and I've got to be careful about this, there is separate UK legislation which will be coming in which will require certain organisations to register, but it's not a GDPR registration. It's under separate UK legislation. But no, I mean GDPR is not about registering, and if you're registered, that means you're fine. Even under the existing data protection laws, you could register. That didn't give you a green light, because it's all about compliance, not about a registration process.
We also had an example a while ago, Simon, and this might be relevant for those who've on the call. I think it was a well-known airline that we will name no mention of, that I sent you an image of, that they had pre-populated the marketing tick box, and this was this is February 2018, and some of these businesses are absolutely not GDPR compliant. They're possibly not DPA compliant. I guess it's just a reflection of the amount of work that businesses have to do out there.
I think that's absolutely right, and I think some organisations may be taking advantage of the less stringent laws at the moment to do these things. But you're absolutely right, Mark. There is more than a mile. There's thousands of miles in a way for many organisations to go to get themselves GDPR compliant, because I think organisations, a lot of organisations have been generally a little bit lax about data protection law, simply because the sanctions haven't been that great. Yes, there is brand damage if something goes wrong, but the financial sanctions haven't been that great. But it's just that GDPR takes that to a whole new level, and I think that's one of the reasons why organisations are going to need to take it seriously.
Okay. Now, if there's any more questions coming through, please do get in contact. We'll hold on the call here for another minute or two, just if there's any more thoughts coming through. I think it's a nice reflection on just the amount of work that the EU, the European Union rather, has to do on GDPR. And quite frankly, when you talk about things like cookie monitoring and the websites having to be compliant even though they have no European Union connection or hosting, I think it's just a reflection of the amount of work that are required to ensure compliance.
And I think there's an additional point to add to that, Mark, is that compliance isn't a once and for all thing. So it's not a case of getting to the 25th of May and going, great, I'm compliant, and then not having to worry about it afterwards. We saw with the existing data protection law, which came into effect in 1998, that the ICO was forever issuing more and more guidance. So you have to keep up to date with the guidance, because ultimately it's the ICO who decides whether you're in breach. And so even if you might be technically compliant with the law, if you're in breach of their guidance, they'll still consider you in breach and fine you. And one of the interesting things, again, diverging away from that a bit at the moment, is that a lot of the guidance that we're expecting to see under GDPR is not there yet. So one of the things we talked about is the technical and organisational measures that organisations need to take to be compliant, particularly around IT security. And we're often asking, what should we be doing on IT security? Well, the simple answer to that is actually the ICO has not yet issued its guidance. So we are now 2 months away or so from GDPR coming into effect, and the ICO has still not issued its guidance on what it considers to be technical organisational or appropriate technical organisational measures that the organisation needs to take. And if you go to their website, they are currently sending you to their existing guidance under the Data Protection Act 1998. So again, we can see, I would anticipate more guidance coming in on that, very shortly, but certainly I don't think it's going to be before the 25th of May, or if it is, how can an organisation be expected to comply?
We've had a question come in here, it might be relevant. I know that the directive has direct effect, but is there going to be a Data Protection Act 2018, and when will it get royal assent?
Yes, there is going to be. Well, there is currently a data protection bill, which will hopefully be the Data Protection Act 2018, and the idea is that it should come into effect on the 25th of May 2018. I mean, one of the things again about GDPR is that although it is EU-wide, there are a number of elements which member states can implement differently in different member states. So it won't always be consistent across the whole of the European Union. So the UK has two issues here. It's where it has the ability to implement GDPR differently, it has to choose how it's going to implement GDPR. So there is a data protection bill which is going to cover that, and it's also covering the fact that GDPR is going to continue as part of UK legislation even after UK leaves the European Union.
We have time for one last question here. I'll read it out, I'll paraphrase it, I think. So I suppose you have 200 emails from an individual about a transaction you're doing with him. Most of it's routine correspondence, but some of it could be personal data. For example, sorry for the delay, I had flu last week, so the personal data meaning health records, I think is what we're getting at here. Later he asks you to disclose all his personal data. I guess then the question is, would that request for information, personal data, include the information we have about the data subject's health?
Yes, it would. Yes, it would. I mean, that is personal data. I mean, the one thing I would say there is that someone might say, well, hold on, have you got consent to process that personal data? And the answer to that probably is there. Well, you won't actually have consent, but one of the exceptions is that you have a legitimate interest in processing that personal data, and for a lot of very sort of routine processing like that, you can probably fit it within this legitimate interest exception. The legitimate interest exception says that your legitimate interest has to be greater than the right of the individual whose personal data it is. And in those types of circumstances, particularly when the information is voluntary like that, you're going to be able to use that legitimate interest exception.
Okay. So I'm going to wrap it up there, I think. So thank you very much for joining us on this webinar this afternoon. Thank you. We hope you found it useful. Any questions received we didn't get around to answering, we'll address by email. We've made a recording of the webinar today, which will be available to listen again from our website, so you or your colleagues, if you wanted to replay it, you could. Please keep an eye out for any future, there will be, for the future free webinars on our website. There'll be different subjects coming up, and we have a pipeline coming up on the next couple of months. But until the next time, thank you and goodbye.
Thank you. Bye-bye.